What are the FCRA rules for employment background checks? Imagine applying for a new job and wondering what checks might be done behind the scenes. You might not realize there are strict rules that protect your rights during this process. That's where the Fair Credit Reporting Act, or FCRA, comes into play. It sets important federal standards for how employers use third-party background reports during hiring and onboarding. These rules are designed to keep things fair and transparent for job applicants and employees alike. First, employers must give a clear written notice that a background check will be performed. This notice has to be separate from the job application and clearly state that a report may be used in the decision-making process. They also need to get your written permission before they order the report. This step makes sure you know what's happening and agree to it. The FCRA covers reports that include information like your credit history, criminal records, past jobs, education, and even personal traits. But it only applies when a third-party company gathers and provides this information. If an employer checks your background themselves, these rules don't apply. Before making a final decision based on the report, employers must follow a process called pre-adverse action. They need to send you a notice that includes a copy of the report and a document called the Summary of Rights under the Fair Credit Reporting Act. You then have at least 5 business days to review the report and dispute any errors or inaccuracies. If the employer decides not to hire you or takes other adverse actions after this review period, they must send a final notice. This notice must include the name, address, and phone number of the reporting agency, along with a statement that the decision was based on the report. They also need to inform you of your right to dispute the report if you believe it's wrong. Employers must also follow federal laws that prevent discrimination. They can't use background check information to unfairly exclude someone based on race, gender, age, religion, disability, or other protected categories. Some states and local areas have additional rules, like ban-the-box laws, which limit when and how criminal history can be considered. In practice, companies should include clear disclosure and consent forms early in the hiring process. They should work with reputable background check firms that follow FCRA standards. HR teams need training on the proper notices and timelines for adverse actions. Keeping records of all disclosures and communications helps ensure compliance. To sum up, the FCRA makes sure employers are honest and transparent when using background checks. It requires clear notices, permission, and a chance for applicants to review and dispute reports before any final hiring decisions. Following these rules helps protect your rights and keeps the hiring process fair for everyone.